good morning, everybody. I'm a bit worried that this morning's seminar has been missold because it was titled the HR Summer Seminar. And looking outside, it's very far from that. But actually, I'm quite glad that it is still the summer because it means that we've got just a little under a year before the GDPR comes into force. In fact, it's exactly 248 working days. Sounds quite a lot, but actually, we all know that it's going to disappear very quickly. So, data protection laws. Just on the slide, summarising what I call the long road to reform, because basically the Data Protection Act that we have at the moment has been around for an awfully long time. It dates back to 1984 when people were very paranoid about information that people had on computers. It was updated in 1998 with the European directive, but pretty much it's stayed the same. And of course, we all know that technology has moved on enormously since then. Current laws predate mobiles, social media, big data, mainstream internet, and all of those things. So of course, it was very ripe for reform. And it took quite a long time coming, but it's here now, and it's going to happen in May 2018 next year. Why is it a regulation rather than a directive? And the reason is that the regulation will take effect directly in all member states of the EU without the need for any implementing legislation. The directive needed implementing under the Data Protection Act, but the regulation will come into force directly in May 2018. And the other reason for that is that it means that there should be much greater harmonisation of laws across Europe. So if you're dealing in a business with multiple offices across Europe, data laws should, in theory, be much more closely aligned than they are at present. I say in theory because it's likely that they will depart. And one of the big areas where they may do is in the area of HR, because there is a specific derogation in the GDPR about HR laws, which enables each member state within Europe to create its own data laws around processing for employment purposes. So something to watch out for if you're dealing in multiple offices, that you may still need to check the local legal position on HR and data. Just to deal with maybe the elephant in the room about Brexit, well, come May 2018, as I said, we will, in all likelihood, still be members of the EU, and so therefore the GDPR will come into force automatically. And even when we leave the EU, we will still have to have laws which pretty much approximate the GDPR. And the government has already said, and the ICO has said, that organisations should start to prepare for GDPR, notwithstanding Brexit, because our laws will remain pretty much in line with the GDPR even after we have left. So I can't cover all aspects in the relatively short period of time that I've got, but I just want to pull out the general themes to maybe identify where some of the big differences are, and also to focus on some of the issues which I think might be of particular interest to those working in the HR field. There's a lot of general familiar principles within the GDPR, thankfully in a sense. So the concepts of personal data and sensitive personal data are broadly the same. Personal data has been slightly expanded. It includes what they call online identifiers, which may not be terribly relevant in the HR world, but is relevant in online. And so data will include, as well as the sort of usual things, data that you might capture on CCTV. It will cover things like building and lift control access data, as well as data about websites visited, phone calls, phone recordings, emails sent and received which contain personal data. So there's a lot of areas where data may be held aside from the HR file itself. And a lot of that data may be in quite unstructured form. So we all know the nightmare of doing data subject access requests in terms of looking for data within emails. And so that will continue and makes it quite difficult to know how to comply with some of the requirements of the GDPR in relation to unstructured data, things like purpose limitation and storage limitation and complying with subject access requests. Those sort of things will still be an issue. In relation to sensitive data, again, pretty much broadly the same definition. It's been expanded a little bit to include genetic and biometric data, and that can arise, for example, if you use biometric building access controls such as fingerprint access to buildings which would now be regarded as sensitive or special categories of data. The actual data protection principles should hopefully be familiar. They're mentioned on the slide, the 6 of them. I won't go through them individually, but hopefully they're familiar. The main one probably being lawfulness, fairness and transparency, something that runs throughout the GDPR. I'll come back to again in a minute. Again, familiar territory, as well as these general principles of good data processing. In order to process people's information, there has to be a legal basis for doing so. And one of the things the GDPR forces us to do is to look much more closely and in a more granular way at the legal basis for processing each type of information that we have. So the main legal basis for processing that people tend to latch on to is consent. And that's still there, but one of the things that GDPR has done is it's made it much more difficult to obtain consent. The requirements for obtaining consent are much more specific. No longer can it be implied or inferred. It has to be it has to be clearly stated and explicit. So getting consent is still a condition for processing, but is much more difficult to obtain. Add on to that a particular issue in the HR world, which is that the regulators have made it clear, not just in the context of GDPR, but for a long time, that relying on consent in the HR field is quite hazardous because in many respects individuals don't really have a choice. So when you have a data protection clause in your service contracts and people are asked to sign and agree to the basis on which their data will be processed, they're not really being given a free choice about that because if they don't sign, then they don't have the job. So in that case, it's made plain in the GDPR that consent will not be valid. And so there are many circumstances where if people don't really have a choice about it, that's not proper consent, and you shouldn't be using consent. The other issues with consent are that there's now a requirement that it should be clearly distinguishable from other matters. So the practice of putting consent into a service contract or bundling multiple consents into one statement will have to be changed. Probably we'll move away from that and have a separate to the service contracts, a separate data protection statement, which has got perhaps multiple layers of consent that have to be signed individually at a more granular level. And again, as at present, one of the issues with consent is that once given, it can always be withdrawn. And so that can lead to difficulties if someone decides to withdraw their consent. And the right to withdraw consent has to be drawn to people's attention. So therefore, because of all those things, the regulators are encouraging businesses to look for alternative grounds to consent rather than to rely on consent. And there are other grounds. I won't go into detail, but probably the main one is the legitimate interests basis, which requires a balance of the interests of the business in processing people's information as against the possible risks to individuals in having their information out there. Just touch briefly on special categories of data, that's sensitive personal data, as well as complying with the earlier conditions. You have to comply with an additional condition if it's sensitive personal data. So apart from getting consent in this area, it would need to be explicit consent. The regulation doesn't tell us exactly what that means, but it's pretty much based on the current law as well. So I mentioned the idea of transparency earlier, and as at present, a key requirement under the GDPR is to make people aware of how their information will be used, what information you have about them, with whom it may be shared, and so on. The GDPR makes some changes first of all, it requires more information than is presently given, and some of the points are mentioned on the slide. Some additional information that has to be set out in data protection statements or policies and the like. And whilst requiring more information, it also says that information has to be provided in a concise, easily accessible, easy to understand form. And so there's a bit of a paradox there, and a sort of conflict. You have to provide more information than at present, but it has to be concise and easily accessible. So one of the actions under GDPR is looking at how information is presented, reviewing data protection policies, internal statements and the like, and bringing them into line with the GDPR. Another sort of key requirement that runs throughout the whole of the GDPR is this issue of accountability. And so the key point is that as well as complying with the GDPR, you have to be able to demonstrate that you're complying with it. And basically that comes down to keeping much more detailed records and documents about your processing. So it becomes a little bit bureaucratic here. But the way I express it is that you're going to have to write a book, if you like, about what data you've got and how you're using it, to make sure that you've got records and documents that set out what you're doing, so that if anyone should ask, you'll just be able to pull that information out. But it has some more detail around it, this concept of accountability. There is a legal requirement to maintain records unless you're a very small business. For some businesses, you may need to appoint a data protection officer if you're involved in large-scale or risky processing. For some businesses, you may need to carry out a formal privacy impact assessment. Some of these things have been good practice recommendations up to now, but with the GDPR, they're becoming statutory obligations in certain cases. And some of these things have a slightly longer lead time, and therefore, if you're in a business which may need to have a DPO or may need to carry out an impact assessment, strongly recommend that you think about it now, because some of those things can take a while to arrange. So moving on to the question of individual rights, this is an area where existing rights are preserved and sometimes enhanced, but there's also some new rights that employees have. I suppose the main bane of HR life is subject access requests, and of course that is a central requirement of the GDPR, that people have a right to access to their information, and that's still very much there. There are changes. No longer can you charge the £10 fee. Not a big deal, maybe, but perhaps that deterred some people from putting in subject access requests. And you have slightly less time to respond. Instead of 40 days, it's a month, although there is scope to extend that if it's a particularly complex subject access request. And there is scope to refuse to comply if it's manifestly unfounded or excessive. These concepts are not defined, and we will need guidance or case law to determine exactly how it works. So we're a little bit on our own as to how we apply those things going in the initial periods. A quick look at a couple of new rights. The ones that capture the headlines: the right to data portability and the right to be forgotten. Data portability means, as well as having the right to access your data under a subject access request, you now have the right to receive it in electronic format. Really that was born out of businesses such as social media platforms and the like, where people want to transfer from one social media provider to another, but it applies equally across all business models and in all areas, and could be problematic in the field of HR, where people's data might somehow get mixed in with company confidential information or intellectual property, and might also include observed information about people, performance data and so on. So potentially problematic. Also the right of erasure, or colloquially known as the right to be forgotten. Individuals have the right to require organisations to delete their data when it's no longer needed. So that might be people who've left the business and who no longer want you to hold their data. and so they can require that you delete their information, which sounds fair but could be actually problematic to deal with in practice unless you have systems that can do that, particularly in relation to the more unstructured type of data. Just a quick touch on international aspects. For those of you that may be working in the UK, but you're perhaps a subsidiary of a international business, maybe with the parent company in the US, HR data is often transferred to the US or the mothership, if you like. There's a big change in the GDPR in terms of bringing into the net businesses that are outside Europe and making GDPR apply to them if they're trying to sell goods or services into Europe. So it can be that some of your maybe parent companies in the US who are selling directly into the EU could be directly subject to the GDPR themselves, and not only by virtue of their local branch or subsidiary. But more specifically in relation to data transfers, for many businesses that is a particular issue as to how data is transferred outside of the EU. And that situation still continues. A little bit disappointing, really. There was an opportunity to bring that up to date with modern forms of computing where data really has no boundaries. But this idea of keeping data within Europe, unless you follow a compliance procedure, is still very much contained within the GDPR and is, apart from some possible new mechanisms that might come up in the future, pretty much unchanged. And so for many businesses, the need to have model contracts in place with other group companies is still applicable, and the possibility of having binding corporate rules within international groups is now not just a recommendation, but part of the legislation. So one of the key elements around data protection is, of course, data security. And we all know that the news is filled almost every week with a new story about a data security breach. And we're seeing this ourselves regularly with incidents coming to us where clients, for example, have done something can be fairly simple, like leaving a laptop on a train, which has maybe got the whole HR file on it in an unencrypted format. So that would be a data security breach. Or transferring the employee data to a potential partner who's looking at acquiring the business in the concept of 2P can be an issue as well. So data security is a key issue, and one of the big changes that comes into force with the GDPR is mandatory notification of breaches. So whereas at the moment, if you do have a data security breach, unless you're a telco, there's no legal requirement to notify the regulator. Going forward, there will be a legal requirement to notify the ICO and possibly other stakeholders and possibly data subjects of a data security breach. That really is a big change in the landscape, and one of the key things to be working on during this period of time between now and GDPR coming into force is an internal incident response plan as to how you would handle a data breach within your organisation. What are the legal ramifications? What are the people and stakeholders you'd need to bring together? What would you need to do? Because the timescales involved in notification are very short. So on enforcement and remedies, I think everybody's aware of the radical change in the landscape in terms of fines for getting things wrong under the GDPR. And it means that compliance with GDPR is a bit of a high-risk exercise because some of the concepts are quite new and are difficult to interpret, and there's little guidance around at the moment. And put that against the potential for very high fines means that it's not for the faint-hearted. As well as the possibility of fines, the GDPR enhances the right for individuals to bring compensation claims. So we will in future see much higher fines than we've had at the moment, but also the potential for class actions, particularly in relation to data security breaches. So just to try and pull a few things together and some ideas as to what we can be doing now in the period in the run-up to the GDPR to move towards greater compliance. So there is still a little bit of time left, but as I said at the beginning, time goes very quickly. It's a team sport, so it's not just HR, but there are other areas in the business. There's probably marketing, there's client-facing areas, there's IT, finance, and so on. So everybody, if you like, within the business needs to be involved and needs to take it much more seriously than perhaps has been the case up to now under the current laws. A good starting point is to do a data mapping and inventory exercise to work out exactly where all your data is and what you're holding and why you're holding it. Are you using third parties? What are those contractual arrangements like, and so on? And document all of that as much as you possibly can. Because of the need for documentation and record keeping, write that book about how you're using data within your organisation. Look again at the legal basis for processing. Are you relying on consent, or are you going to be relying on legitimate interests, or one of the other bases for processing? And maybe in some areas it's consent, and in other areas it's legitimate interests. And if it's legitimate interests, well, you need to just expand on that and work out what exactly are those interests and what are the potential risks to the data subjects, and write that down as well. Look at your consent mechanisms, unbundle them from contracts, and be more granular about the consents, and provide mechanisms for people to opt out and withdraw consent if need be. Look at sensitive personal data. What sensitive personal data might you be processing? Inevitably there are some. And on what basis are you doing it? Are you looking at explicit consent, or are you relying on a legal basis within the employment world? Look at your policies and procedures. Dust off the old data protection statements and policies and bring those up to date, something that needs doing. And review your data processor arrangements. So you might deal with third parties for payroll, for example, or benefits providers. Look at those contracts and how data is treated. There are enhanced provisions under the GDPR about what needs to go into those contracts around data security. And look at how you can deliver these new rights, subject access requests, how you would deliver data portability if needed, and how you would deal with a request to be forgotten. And put in place that incident response plan that I mentioned. If, heaven forbid, you have any data security breach, that you've rehearsed how you would deal with it and you're able to respond quickly for damage limitation. And finally, make sure everybody is aware and that you've carried out training of staff who are handling people's information so that they are up to speed on the new regulations. So that's a very quick roundup. I'm going to be around afterwards for any questions, but I'm happy now to hand over to Emma on tax. Thank you.